Good morning. Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, as you can see on the screen, and I am an employment lawyer at Samfiru, Tumarkin, LLP, and I will be answering all of your questions about all things employment law for the next 30 minutes or so. As always, Samfiru Tumarkin is Canada's leading employee side employment law firm. A couple housekeeping notes. If you want to contact us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, that's it. Still waiting for some questions to pop in. Please send. Hold on. Might have some right here. Nope. There we go. Please try to get your questions in as soon as you can. I want to get through all of them if possible. And if you get them in earlier, it gives me a better chance to not only answer your questions, but if you have follow-up comments or questions after I answer your questions, you can get those in before the end of the broadcast. So let's just get into it, and please send in your questions. Okay, question from Lynn. Hey, I have a question about getting paid for stat holiday in British Columbia. I've been working full-time for a few months and believe that I meet the requirements. Employed 30 days and worked 15 of the last 30, but I'm wondering if that means my employer has to pay me for a stat holiday. I'll ask my manager tomorrow, but wanted some insight first. I would just check BC employment standards to find out if you do qualify. Fairly straightforward. It'll either be on the actual, you can look at the actual legislation, which if you Google Employment Standards Act, BC laws, you can see it there. Or you could just Google your question and you'll get an Employment Standards branch website that can answer it. Generally speaking, if you're not an exempt employee and you work a statutory holiday, you should get paid for the statutory holiday for the work that you do at time and a half. So, but it's not something that comes up in my practice very much. So I would Google it first and take a look at the Employment Standards Act and Employment Standards Branch commentary on that particular point. Question from Ranger. My contract said the position would be hybrid, 2 days in the office, but management later changed to 3 days. They also took away flexible hours and now require 9 to 5:30 shifts plus, in quotes, jam sessions on Thursday that keep us working until 9 or 10 p.m. None of this was in my contract. Can my employer legally keep changing my hours and expectations like this? All right, well, we'll start with the first one. In terms of the working hybrid, so you were hired to work hybrid, some days at home, some days in the office. That's, I'm not going to say it's standard, but it's very common in white collar jobs now. A little bit at home, a little bit in the office, and the ratio of days in the office to at home. Yeah, I'm sure they can move it around, and it's not really that big a deal. The question is, if it's in your contract and they change it, or have they breached the contract in some fundamental way that you have a constructive dismissal? I mean, the short answer is probably not. I don't think there's, so what? There's no real value to that. Unless there's no fundamentality. So unless there's a child care reason that you brought to their attention, or maybe an elder care reason you brought to their attention that you couldn't work this additional shift in the office, I don't think that's really anything. There's no remedy that comes from that. I also don't know, if you haven't been in your job for very long, the remedy of constructive dismissal, which would be your only remedy, which I don't think you have, but if you had it, would terminate your employment, and you'd only want to do that if there was significant value to doing so. They also took away flexible hours, now require 9 to 5:30 shifts. Well, I don't know what your hours were before. Now, if you could just dictate your own hours, and that was part of why you accepted the job, that might be different. That could be a constructive dismissal, again, depending on the reason why you needed flexible hours over 9 to 5:30, and there'd have to be a bona fide reason, again, childcare, elder care, some other family responsibility. I mean, most people work around the hours that you're listing, and your employer requiring you to work more standardized hours. I don't think anything really turns on that unless a central reason as to why you accepted the job was the flexible work hours, and that was for a specific reason that carried fundamental weight, such as, again, childcare, elder care, that kind of thing. Jam sessions on Thursday, where instead of ending at 5:30, you work till 10, and are you getting paid for that time? Is that just bundled into salary? That could be a problem. Depending on if you're overtime exempt. If you're not getting overtime, then maybe you should be getting overtime for that. But I would, in these situations, and do you like your job? Is this something where you can talk to your work about perhaps getting paid overtime for it? Finding some sort of amicable resolution with your employer, because your alternative resolution is to bring some sort of complaint through the Employment Standards Branch if your employer is provincially regulated, and most employers are. And so if you do that, chances are you're gonna sour the relationship, and you probably eventually won't be working there in the future. Although they can't fire you right away for bringing an employment standards complaint, because then you'd have it's called a make whole remedy of we'll call it back pay from the date of termination to the date of hearing, which might be as much as 13 months. But so it's a tough one depending on the situation in terms of you wanting to get compensation for that, if that's what you want. Could you claim constructive dismissal because this is a fundamental altering of your contract? I mean, I've never heard of that, where loading on additional hours is a constructive dismissal that they're not paying you for. But theoretically, could it be? Yeah, I think it could be. But I think a much safer road for you in this situation is just to, I wouldn't worry about the hybrid thing at all. I wouldn't worry about the standardized shift thing at all, unless the reason why you accepted the job was because of that, and you had an important fundamental reason as to why that you needed that flexible work hours. But otherwise, I wouldn't worry about it. But the jam sessions could be a challenge if you're not getting paid for them. But I think the solution there is to talk to your employer and see. But you got to be careful with that, though. Like if they all want you to drink the Kool-Aid. I've never heard of jam sessions, but it sounds like you're brainstorming about something and they want you to drink the Kool-Aid and be on board with everything the company wants. And if all of a sudden you're saying, well, hey, I'm not getting paid for these, then you're on the outside, and maybe your vertical mobility in the company or longevity in the company has been reduced. So you got to think about all these things. I mean, the short answer is there enough there to pursue a legal remedy? Probably not. So then the question is, how much are these things bothering you? Should you vote with your feet and go find a different job? Should you pursue some sort of compensatory claim for this unpaid overtime? It's small enough money that I probably not. But if it's stacked up for a while, and then you brought a claim in the Employment Standards Branch, maybe. But it's really just sort of one of these things where there's a lot of mini annoyances, none of which produce an actual legal remedy for you. And the one that does potentially require some sort of solution, the jam sessions, maybe just talk to your employer and see if you can work something out there. Again, I don't know your employment situation. I don't know what the employer is like. Use your best judgment in that situation. But yeah, there's not much in the way of legal remedy. Okay. This is, someone sent several messages, so I'm going to try to, oh no, maybe it's just two. Okay, so kid is born on September 27th, and I started a new job September 20th. Do I get paid paternity leave in Nova Scotia? I actually am not familiar at all with the paternity leave structure and how that works. I think you can divide. It's actually through Service Canada, so it's federal. But in terms of some of the payment, I think you could divide it between maternity and paternity. But I just I just don't know the answer to that question. It's not something that comes up in my practice. So, however, the answers to that are readily available. I don't know if are there any challenges around. Did your workplace hire you knowing that you might go on paternity leave right away? You start on September 20th, 7 days later, your child is born, and you immediately go on leave. I just make sure that your employer obviously has to let you go on paternity leave, but you want to. I think that's a tricky situation with your employer. They may not be pleased with you about that one. So you'll want to make sure your employer's on side with it. In terms of coverage for money, talk to Service Canada, talk to your employer. It pretty easy answers you can find fairly quickly for that one. Question from M. Work just completed on a market review and have come back saying I am paid too much based on the new pay scales. Okay, they developed, I'm guessing the company, a work just completed, they developed, okay. Market review and have come back saying they paid too much based on the new pay scales they developed as a result of that review. My pay will be frozen for the next 2 to 3 years, not even cost of living increases until the scale is balanced. I'm not the only one impacted. Do I have a case for constructive dismissal? No. The short answer is no. So constructive dismissal is where your employer changes, we'll just say breaches a fundamental term of your contract of employment. So when it comes to pay, it would be a pay reduction, for example. Usually if 20% or more is an automatic constructive dismissal, it's 20% or it's less than 20%, there's got to be something else, usually like a demotion or some other indication of perhaps repudiation that could get you to constructive dismissal. But not giving you raises is not a fundamental change to your employment. There's no guarantee of raises. It's become standard in most companies to just give cost of living adjustments. I worked at an employer for many years where we just got 2 to 3% raises every year to keep pace with inflation. Didn't really matter what our performance was. It just sort of got built into the entire structure, and that happens in many employers. But you don't have a right to a raise. But where your rights kick in is if there's been a breach of a fundamental term of your employment, and that just simply hasn't happened in this situation. So if you don't like the way your employer is treating you with this, listen, a 50-foot view here. 50-foot view, your employer comes in and says, hey, we did this market review, probably for the purpose of, because we don't want to pay you. The result was, we don't want to increase your wages. The result was, surprise, we didn't want to increase your wages and we're not going to, or we're paying you too much, so now we're not going to increase your wages for 3 years. If you don't like that, look around. You've got time, you've got a job, use it as a working notice period and go find a different job and then move on. Right now, you could have reasons why you need to stay at this job. Maybe it's paying you more than you get on the open market. Maybe your vocational mobility is low at this point. It is a contracting employment market. So, but you have the opportunity to look around if you don't care for it. But do you have a constructive dismissal, or don't care for the way you've been treated? But do you have a constructive dismissal? Short answer, no. Okay, so a bunch of questions just came in. I don't know. No, there's not that many. Okay. Ken asks, payroll clerk on stress leave, medical certificate, can employer ask questions? Question 1, this illness prevents a person from working because. 2, does this person have cognitive demand restrictions based on medical risk? So this is always a tough one. I think if you go on stress leave, your doctor says you're unable to work at this moment, I'm of the view that you can rely on your medical provider medical notes. The only reason why that this additional questionnaire needs to be filled in is if there's a doubting of the veracity of the medical diagnosis, which I imagine in this case, if it's just the beginning of it, isn't really there. So I think, Ken, you probably need to get a lawyer on that one to stick handle that for you, because you don't want to get that one wrong. You don't want to be in a situation of, in effect, I guess it wouldn't be frustration of contract, but you don't want to be in a situation where you don't provide a sufficient documentation to your employer, which could result in some sort of termination if it gets to that point. But if you've got a medical note that says you're on medical leave because of mental health issue, I think that's sufficient for now. And if it drags on, or if you want to come back to work with certain limitations, then sure, the medical note could be justified, or the medical certificate could be justified. The challenge with the medical certificates is when they get filled out, quite often doctors will say things that can be fatal to your employment law position. If you're trying to preserve your position to money, we'll say, and your doctor says something like cognitive impairment permanent, well, your employment is done, you don't get anything, right? So those things, I'm not a big fan of those. I just don't. You got to find out with a lawyer, if, like, who specifically analyzes your situation, if you actually are required to fill one of those out and provide it. Again, you can reach us if you want: employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. I would not do anything until I talk to a specific lawyer about your issue, Ken, because these things can go the wrong way on you, and you can end up not having a job as a result. So I would certainly talk to an employment lawyer and get specific, tailored advice before I did anything else. Raj asks, I asked for accommodation due to a disability, and now my manager is giving me impossible deadlines. Is this harassment, or just poor management, or they're just building a case to get you out of there for just cause? So did you provide a medical note for your accommodation for your disability? Right? That's the first thing I would ask. If not, you should do that. And are the impossible deadlines that you're listing, are those infringing upon the accommodation that you are seeking? Right? So if you need to, instead of being able to lift 50 pounds at work, you can only lift 30. So you need more. You need to be restricted to 30 pounds, which means it takes you 30% longer to do a task. And then he's giving you multiple of the same task, which are impossible with your reduced productivity. Is that what you're talking about, or are you talking about something else? The question for you is: are they infringing upon? Are they providing those accommodations? Number one. Number two, are they infringing? Are these impossible deadlines infringing upon them? I would record everything for now. If things continue, like in a journal, just who asked what and when, and the result. It just can be short bullet points. You just want to know when it happened, what was asked, and who was involved. What you said. I would just be calm, throughout the entire process of these things happening. But it seems like this may be going towards a termination claim. So you want to record everything, and if something else happens, you should talk to an employment lawyer. I mean, you can talk to one now. It doesn't. I don't have enough to really go on to say that you need to do that for sure. But it sounds like it's building towards that. So, and at some point you're going to have to. Tara asks, I was offered a new job, but the employer won't send a contract and says that that's because it's at will. This feels like a red flag. Is that legal? Okay. I'm just going to back up here a second. It is an implied term in everyone's employment that your employer can only terminate your employment by providing you with a reasonable notice of termination or pay in lieu of reasonable notice. Reasonable notice is a term of art in employment law that means an assessment by a judge of 4 factors informing your severance: age, length of service, position, availability of similar employment. Judge puts those numbers into a blender. At the top of the blender comes a number measured in months for your reasonable notice, which, if you're terminated that day, becomes severance. And severance is really just money for your termination. The rule of thumb for that is about 1 month per year of service to a maximum of 2 years. It can be a lot of money. Okay. But employers can limit your ability to get this big severance by, at the time of contract or the time of your hiring, or even later, forcing you to sign an employment contract, or getting you to sign freely an employment contract that limits your severance upon termination to something less than, we'll call it the big severance, quite often to the statutory minimums, which are maxed out at 8 weeks. It's quite a huge difference, 8 weeks versus 24 months on the high end. And so if you never sign a contract, that's almost always good for you. Contracts are there to help your employer, not you, and specifically to help your employer limit its liability to you upon termination. So if they don't give you a contract to sign, great, don't ask about it. If that contract says at will, they do give it to you and it says at will, great, that's a violation of the Employment Standards Act, and therefore you get, assuming you're provincially regulated, and therefore you're going to get the big severance that I just talked about. So if they're not giving you a contract to sign, great. Now, is it weird and is it a red flag generally? Yeah, but it puts you in a better position than if you had a contract that limited your termination entitlements. So I would stop asking them about it and just do your job. And down the road, you might have a good severance claim, provided that they don't make you sign, or you don't sign a new contract later on that limits your termination entitlements. And if they ever say, here's a contract to sign, don't sign it before you talk to an employment lawyer. Okay. Any questions we have? A few more. Okay. April asks, I have been unjustly terminated. Human Resources reported on my record of employment payment of $15,000 in 2024 that I never received. The union has not done anything. What can I do, and legal rights that I can pursue? I don't handle union side work, so I can't comment on that at all. Generally, the first stop for you is your union representative. If that is not assisting, certainly there are lawyers who can assist, who do that kind of work. After 12 months of service. Okay. G asks, what is the most likely impact on common law damages? That's the big severance we talked about. If later, after termination, the employee gets another job, it's effectively fatal. I mean, it's not always, but I shouldn't say it's effectively fatal. It depends on what you're making at the new job. But if the new job, so if you're not entitled to double compensation after you lose your big severance entitlement, okay, you're not entitled to double. Well, let me put this a different way. So after you've been terminated, you have an entitlement, assuming there's no contract that limits your termination entitlements. You have an entitlement to big severance. That entitlement is not unfettered, however. You have to make reasonable efforts to look for a new job. And if you find a new job, you're not entitled to double compensation. Any money you make at a new job is deducted from your severance entitlement. So to give you an idea of how serious this is, if you have a job that, if you get terminated from a job that's paying you $80,000, and the next day you get another job, a new job that pays you $80,000, your severance claim is worth zero beyond the statutory minimums they provide you. So it's very serious, and it can be, in many cases, fatal. Sometimes, though, if the old job pays you $100,000 and the new job pays you $30,000, then the across whatever your severance period is, the new job earnings are deducted from your termination, your severance entitlements. But there's still a lot of money left in the pot there, and there's a good claim to that money. It's just reduced because, again, you're not entitled to double compensation. It's a dollar for dollar deduction. But it can be very serious. Okay, Ken's back. We got 2 more questions. Ken's back. He's non-unionized. He's been working for 15 years, payroll clerk, currently on stress leave. how soon should I submit my retirement notice? I don't think you should submit retirement notice at all. Ken, I said earlier you need to talk to an employment lawyer. If you say, so I've been talking a lot today, backing up here, about severance. Severance is money you get after you've been terminated. Severance money can be quite lucrative, quite valuable. It can be as much as 2 years of pay, depending upon your age, length of service, position, and employment contract. However, you're not entitled to it. The purpose of severance is to tide you over until you get your next job. Okay, you're not entitled to it if you are going to retire. Okay, because you have no intention of work, so you don't need the money to get you to the new job. Okay, so no one should ever say, I'm retiring without if they're trying to pursue a claim without talking to an employment lawyer first. Okay, so I recommend strongly against saying that. That's number one. Number two, you need to talk to an employment lawyer immediately. I will give you the details at the end. They're still on the screen right now. Brennan asks, last question. My employer started firing people for not meeting goals, but these goals are unrealistic. They're using these to say they have cause and let people go with no severance. Anything we can do? Yeah, I have lots of clients like that. Quite often employers will use, they'll change targets, they'll change sales targets, metrics, whatever, and then start giving performance improvement plans to justify termination for just cause. It's challenging for the employer to do that, particularly if there's been long service. In the first couple of years, maybe not. But termination for cause is where the actions of the employer have effectively extinguished or not. They've vaporized the employment relationship, and you can get there with progressive discipline, but you need quite a bit. I mean, and the longer you've been with the employer, the more progressive discipline you're going to need, and there needs to be a through line through it, more or less. Where it's a consistent thing, like he's late here, he's late here, he's late here, he's late here. We've been giving him written warnings, still no improvement, that kind of thing. Not meeting performance targets after they've been changed, it's a tough one for the employer. So yes, I do think there's something you can do, and if you do get terminated, you should talk to an employment lawyer, and I'm going to put our information on the screen. So if you want to talk to us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, that's it. We got to everyone's questions. That's good. Thanks for sending in such great questions. Join us next week. There we go. October 27th, Monday, with Chris Justice. He'll be at 1:30 p.m. Eastern time. He'll be answering all your questions about all things employment law. Other than that, thank you for the good questions. Have a wonderful and safe weekend. I will see you back here, I think, in 2 weeks at my regular time slot, 10:30 a.m. Pacific time. Have a good weekend.